In the matter of McGinnis versus Bard, will we please have appearances of counsel?
Good morning, Chief Justice Radner. Adam Slater on behalf of the plaintiffs. I have my associate, Chris Geddes, here. I'm not sure if I was officially allowed to enter an appearance, but I'd love to tell the court that he's here with me since he did most of the brief writing.
Welcome.
Thank you.
Good morning, Your Honor. Jared Placitella for New Jersey Association for Justice.
David Cott, KOTT. I'm joined by my partner, Natalie Mantell. We're with McCarter & English, LLP.
Good morning. Daniel Rogers, law firm of Shook, Hardy & Bacon, on behalf of the AMICI, the Advanced Medical Technology Association, the Chamber of Commerce of the United States, as well as the National Association of Manufacturers.
Please the court, Charles Cohen from Hughes, Hubbard & Reed on behalf of amicus, curiae, New Jersey Defense Association.
Good morning, Your Honors. Ryan Kurtz of Patterson, Belknap, Webb & Tyler on behalf of the amicus, curiae, New Jersey Civil Justice.
Good morning to all counsel and welcome. With the abundance of fine counsel that we have this morning, I'm going to ask that to the extent you can incorporate arguments that have preceded you, please don't hesitate to do so. Mr. Slater.
Chief Justice Radner, I would like to reserve, if I've been accorded 30 minutes, 8 minutes of that for rebuttal, if I could, please.
It's a bit more than we usually grant, so we'll have you back.
Thank you. I was being cautious because there's so many people after me, but whatever the court...
Let's count on 5 and let's see where we go. Please go ahead.
Thank you. Chief Justice Radner, Justices of the Supreme Court. The Appellate Division is the only appellate court in the United States to have reversed a finding by a trial court, a discretionary finding to exclude 510K evidence. The decision, essentially from our perspective, is very equivocal and ultimately substituted its own judgment for that of the trial court, which did a superlative job of handling a very complex case and considered every argument that was raised on appeal and that was considered by the Appellate Division. The Appellate Division agrees and acknowledges that the trial court found that there is no safety purpose to 510K, that there is no device-specific requirement that was ever enacted with regard to these devices, acknowledged the risks of confusion and prejudice, and said that those were legitimate concerns of the trial court, and yet reversed the decision as well, recognizing the overwhelming weight of authority in the federal courts of appeals that have reviewed these decisions, including in the pelvic mesh litigation from the federal MDL, all of which affirmed the discretionary decision by the MDL judge to exclude 510K. Ultimately, what the Appellate Division did in ordering a 104 hearing was to essentially say, well, take another look at this, but without any specific finding of something that the trial court did not consider below in its very exhaustive review of the record. 5 hearings were held at different points during the trial. Extensive proffers were made, and there's really no explanation for why the 104 hearing would truly be necessary if the abuse of discretion standard, which has to be more than words, which has to be a policy of our courts that allows trial courts and trial lawyers to know that there's going to be finality accorded to evidentiary decisions in complex cases. Otherwise, you end up with a situation like this where we're now 5 years after trial. The plaintiffs are still waiting for their justice to be finalized, and under the appellate decision have to go back and retry the case and likely come back up on appeal and extend this case for years more.
You mentioned that there's no safety purpose to a 510K. I read, of course, Lohr and Regal, but weren't both of those cases talking about the 510K process as it applies to a device that existed on the market before 1976, for which there is no, the original device doesn't have to be shown to have been safe and effective at any point. There's this grandfathering clause. For a device that's introduced after 1976, doesn't the predicate itself have to have been found safe and effective in order for the predicate to have been sold if it was introduced after 1976?
I don't believe so. In fact, I believe that that distinction, which obviously is raised in the papers from the defense and from amicus on the defense side, it really is pointing, I think, to the Safe Medical Device Act in 1990. But if you look at the legislative history, which we cited, it actually recognizes that what that regulation did was incorporate the policy that already existed. These devices emanated from a finding by a panel in 1988 regarding surgical mesh, which was a broad term, and actually in the language of that finding talks about surgical mesh used for hernia repairs and for orthopedic bone joint surgeries. That is ultimately where all of this began. So I don't believe that these devices are linked to a predicate that actually was found to be safe and effective through the pre-market approved process.
So that seems like a disagreement with the level of specificity at which the FDA is undertaking the 510K process, rather than, are you disputing that the surgical mesh, even if you think that the surgical mesh is not related or the same technologically as the product in this case, do you agree that the surgical mesh in 1982, I think the FDA mentioned, it has an established history of safe and effective use, and then in 1988, they officially classify it as this Class 2 device, which means that they have found that it is safe and effective?
I'm glad you asked that question, because I think that that's an issue that permeates, sort of underlies a lot of this. In fact, the FDA did not really make a safety finding. Okay. And when I talk about safety, I want to talk about, and I'm hoping to communicate this during this argument today, what happened at trial. Because one of the issues that's obviously raised by the appellate division is the suggestion that in trying the case, I took advantage of the decision by talking about the lack of clinical studies. Your question really wraps into that, because these devices are actually surgical systems, and they were sold as procedures and systems. It was not just the mesh. And in fact, the scientific and medical literature, which was really at the heart of the case, talks about these as procedures utilizing mesh, but also utilizing the instruments to place it in the body, and these innovative, unfortunately it turned out to be poor innovation, and these products don't exist on the market anymore. A fact that the trial judge, in his discretion in balancing the trial, did not let the jury know either, that the products had been withdrawn. The criticisms are of the procedures. The mesh is a part of it, and it's a part of the problem, but ultimately, at trial, what we were arguing about was the medical risk benefit to establish safety for these procedures. And that's what we were talking about when we talked about clinical studies at trial. In fact, the 510K process does not incorporate a medical risk benefit at all. If you look at the actual regulations and the actual statute, whereas pre-market approval actually requires a risk-benefit analysis, this entire trial was focused on the concept of medical risk-benefit. So, for example, when the appellate division says, well, it was unfair not to let the defendants tell the jury at least that the FDA did not require clinical studies, when you look at the forms that are cited in the appendix, and I have all the sites if anyone needs them, it's actually the checklist, were clinical studies needed to prove substantial equivalence? Not were clinical studies needed to prove safety. Substantial equivalence was never a question at trial. It was never an issue.
I understand, but I want to make sure that I understand your answer to the predicate. So if you're proving substantial equivalence to a predicate that was proven safe and effective, are you alleging that the predicate was never proven safe and effective, or just that this device was not connected enough to the predicate such that the FDA should not have issued the finding of substantial equivalence under 510K?
My understanding is, from all the language and all the case law and everything we've researched, that there was not something in the tree going back to the root that was actually found to be safe and effective under pre-market approval. This emanated from a panel decision classifying surgical mesh in 1988 as Class 2 and allowing 510K to run from that point forward. So to our knowledge, there is no pre-market approved product in the chain. And it's a good question, because even if there had been, There was never a showing that a particular device in the chain was pre-market approved and that this product was so similar that a safety finding would be equivalent. That was never submitted. There's nothing in the record. There's nothing in the FDA expert for Bard who was Proffered's report or her deposition testimony. It's just not an issue that was ever raised.
So your argument isn't that the surgical mesh is unsafe?
Well, my point is surgical mesh, and I want to be sure that I'm getting my terminology right. When you say surgical mesh as a category, or the mesh in the Avolta and Align product itself, because they're two very different things.
The FDA panels and 82 approved and said that they were reasonably, that they had a good history of being safe and effective. Established history of safe and effective use.
The surgical mesh that was the subject of the 1988 panel finding could be safe if it was used in an indication through a procedure that would safely use it. But the thing with 510K is it doesn't say this is how it's going to be used in all cases. It's a very broad finding. I mean, just look at what we have here. We have gynecological devices for pelvic reconstructive surgery that are put in with complex operations that were revolutionary according to the industry and according to companies like Bard that changed the face of pelvic surgery for women with prolapse and stress incontinence. This was a completely new use, and it's not just the mesh material, which, by the way, is not the same mesh material that was approved in 1988 or was cleared in 1988. It's very different. This is polypropylene. There's various pore sizes. There's various weights and densities, which, again, at trial, we were arguing about the differences between various polypropylene mesh materials as one part of the system.
Didn't the FDA find that this was the equivalent, that this mesh was the equivalent of what it had already decided had an established history of safe and effective use?
All the FDA did was find that it's for the same intended use in general, meaning to be put in the body to support some structure, and that there's no different technological characteristics. That was the finding. There was no finding of safety.
That sounds like an objection to the 510K process itself. It sounds like you're saying that the FDA is allowing too much of a difference between the predicate and whatever the new device is that's trying to be used and still finding substantial equivalence. So is that your argument, or is it that the predicate was never safe and effective to begin with, or is it both?
Well, I think that it's both. I mean, we could have a discussion, which is in the literature, about whether 510K should even be in existence, and there's a large controversy that it's acknowledged in the literature over that question, but we don't have to answer that question today. The only question today is, does 510K provide so much probative evidence that that probative value outweighs the massive prejudice that even the appellate division and every single case cited by the defense allowing it in has acknowledged? I mean, I take the Davol case, which I found the defense actually cited from the Davol hernia mesh case, where the judge said, well, I find it's not about safety. I'm not going to let any expert talk about the 510K process because that's going to be too confusing. There's going to need to be a significant explanatory and limiting instruction. And the judge said something very interesting in the footnote to that decision. The judge said, now I'm aware of all these Circuit Court of Appeal decisions that have affirmed every judge that has said it should be kept out. And what the judge says is that is a function not of the fact that it can never come in. I would disagree with that, but I don't have to win that battle today. But it's a function of the abuse of discretion standard that's applied. And that's really where we are in this case, that I think these are very good questions, and I have strong feelings on these things, whether or not 510K should exist at all. But it's so limited, and it's so tangential to the concept of safety, that it should not be a piece of evidence at a trial where the entire issue is, was the product designed in a safe and effective manner based on a medical risk benefit, and were the warnings adequate based on a medical risk benefit? And I'm sorry.
Go ahead, finish.
And I was going to say, and there are many issues that were in this case that actually don't even translate to 510K at all. For example, the implanting doctor testified she never would have used the product if she knew various things. One of the things she assumed, based on the statements and the claims made in the instructions for use, which is the package insert, was they must have had long-term data to make all these claims and to say all these things. She assumed that, and it was one of the bases for her using the product. And she said, I didn't know that. I wouldn't use it if I didn't know they don't have long-term data. That has nothing to do with 510K, and 510K doesn't speak to it. So again, this would confuse the proofs extensively, and the trial judge, who knew this record, of the 25 witnesses that were coming in, the 10 experts, and understood all this, balanced all of this, and made a reasonable exercise of discretion. And that's really at the heart of what we're here for today.
Does it matter that Mrs. McGinnis had both the Avalta solo device to correct prolapse implanted as well as the Align device to treat the stress urinary incontinence?
When you say does it matter in the sense of...
Well, one of those products, the Align, is still on the market.
It is not.
But is that technique, that sling technique, is still on the market?
Well, it's a good question. In general,
Right.
In general, the mid-urethral sling by the transobturator approach is still on the market for a couple of devices. Virtually every one of them is no longer sold. And it's very interesting because there's tremendous literature that we used in this trial where scientific literature, peer-reviewed, said that obturator armed mesh should no longer be used because the problem is it goes through the groin where the obturator and pudendal nerves are in an area where it's not a gynecologic area. It's an area where gynecologists are not even trained to operate in the groin. So now they're putting the mesh into this area and they're creating all new morbidity, tearing through nerves, tearing through muscles, and that is one of the main problems for Mary McGinnis. So where I actually would like to take this is one of the real big problems is they never told anybody if you're going to put the Avalta with the armed obturator arms into the body and the Align with the arms, you're doubling the mesh load in the groin, and our expert, Dr. Weber, made a strong point of that because the mesh load is a key to how strong the inflammatory reaction, how bad the scarring is, how much shrinkage and contraction, and this cascade. And if you saw on the record, Dr. Raz, who ultimately operated in California on Mary McGinnis, he had to go into her groin, not through the vagina, through the groins, through the legs. He had to take out the mesh. It is incredibly morbid, very difficult surgery. And he had to actually use electrocautery to take the mesh off, which he described as being cemented to the pubic bone in the ischial spine. So again, this procedure was so horribly unsafe that the science and the medical community around it has said obturator slings are so dangerous they shouldn't be used. And I can tell you, less and less are used every day. And I'll bet dollars to donuts you won't see these procedures being done 5 years from now because so few of them are being bought by doctors now, the sales are going down. So because doctors are recognizing, and I'm in these depositions all the time, I hear the doctors saying, I won't use obturator, I'll only use a different type. Because the slings, and this is another one of the 510K issues, mid-urethral slings can be placed in the obturator or they can be placed in the retropubic space up through behind the pubic bone. Very different surgery. You don't touch the groin. You don't go near the pudendal nerve. And again, that's what Mary McGinnis has. She has pudendal neuralgia. Her pudendal nerve is so badly damaged that she can't sit for more than a couple minutes. She stood during most of the trial in the back of the courtroom and stood and she testified for the most part.
Can I stop you for 1 second? Because I really...
Can I steal the water while you're doing that, Justin?
Absolutely. I get there was a long and complicated and involved trial involving what the plaintiff argues is a defective product. We're concerned with 510K, and it sounds like what your argument, distilling it down to something that even I may be able to understand, is that this was a new use for the mesh that had been approved, and therefore 510K doesn't apply because it doesn't apply to a new intended use that has different risks, different hazards, it just doesn't apply here because it's a new intended use.
I'll rephrase it slightly. Please. I don't think it should apply, and in fact, you probably saw in the record, the FDA reclassified the prolapse devices like the Avalta as class 3 devices once they learned how dangerous they were. And one of the problems...
That all postdates this.
I realize that.
I'm just asking, it sounds like your argument is that why do we need a 104 hearing? Why do we need to even consider 510K? Because this is not the same device. This is a new intended use which takes it out of 510K, and we're talking about the wrong things here.
I think that's one of the strong policy reasons to not elevate 510K to being admitted, because 510K is so big. It lets everything through that can fit this general category of the mesh. And again, doesn't look at how's it being used? What is the medical risk benefit of this? What part of the body? How being placed? So I can't argue that it cannot get in through 510K because it did, and we're not challenging the FDA finding. That's not for me to do today. But I think that it points up how weak 510K is and why the probative value, we would say none, is so, even the courts that have allowed it in has said it's so low that that you don't let it in because the prejudice is so massive.
So the main part, so going back to what your argument is, considering what occurred in this case, there's no need to find, the appellate division shouldn't have found that there was any abuse of discretion here, considering everything that the trial court considered during the hearings. There's no need for additional 401 hearings, and we should not find that the trial court abused its discretion.
That's the bottom line of my argument. And I'll tell you something very interesting, because again, I guess I came in here sensitive to the clinical studies issue because that was sort of permeated the decision. This is from the FDA expert for Bard in the proffered report, one of the opinions she was going to give. Even if a clinical study comparing the Avalta to predicate products had been directed to be done by the FDA, because as I've explained, that only goes to is it substantially equivalent to something else, not to prove it's safe and effective, that would not answer the questions raised about the transvaginal mesh placement of surgical mesh for prolapse repairs. Even their own expert admits that the type of clinical study the FDA would order in a substantial equivalence review under 510K would not answer the safety issues which were at the heart of the trial.
Sorry, go ahead.
How do you interpret the appellate division decision? It orders a new trial, it orders a 104 hearing, but says it doesn't prejudge the outcome of the hearing. Is the trial court, under the opinion of the appellate division, obligated to allow some of the evidence to be introduced? And if not, what's the basis for a new trial?
I agree. The appellate division explicitly says they're not prejudging the outcome, and they're not saying that the judge can't come out with the same decision as before. It just says they want it more deeply reconsidered. Why was a new trial ordered? Why was this done? I mean, we obviously sharply disagree, because what if, I think where you're getting is, so if the trial judge says, well, you know what, I did this hearing, I heard everything I heard before, I let someone testify to it, I have the same outcome, now we have to retry the case when everything else was found to be appropriately handled and there's no other issue. So it's grossly unfair, and again, in a case like this, it's a bit puzzling as to why that finding was made, because now you put, obviously, the McGinnises through another trial, another appeal, massive expense, and they're getting older. Mary's 76 years old now. It's tough.
Can you address an argument that the defense has put forward that fewer than 2% of products on the market go through the full pre-market approval process, and that the legislative history suggests the PLA was not intended solely to address that?
Well, I think that what that tells us is 510K was an industry-friendly exemption, and the courts talk about it. It was meant to promote competition, to let other companies copy basically something else that was out there and go and sell their medical devices more quickly and cheaply. So that's what 510K is for. The fact that very few devices go through pre-market approval is because who would ever want to do that? If you saw the documents and the testimony, speed to market was a concept in their PowerPoints in the marketing department, which ran this whole thing, which was we need to get to market quickly because other companies are ahead of us, and if we don't start getting doctors to start using our product, we're going to be left behind and never get a bite of this multi-tens of million dollars market. And that was what motivated this entire exemption from our perspective, was to let companies get products to market quickly.
But didn't the FDA's order in this case so it was a multi-month review of the 510K submissions, correct?
I don't remember the exact time period it took them to get it. It was maybe a few months.
And then didn't their order say something like the subject device's components have been adequately assessed via biocompatibility determinations for safety and via physical strength and characterization assessments for prediction of effectiveness, then the product is substantially equivalent. So isn't this because again, the predicate was already held to be safe and effective, isn't the finding of substantial equivalence specifically for safety and effectiveness, not just that it's the same as a device sold before 1976 that had been grandfathered in?
No, because what they're actually evaluating is is it substantially equivalent to the other meshes? Can it basically, it's an ISO, International Standards Organization standard that all of these mesh companies use, and it really steps into an area I was hoping to talk about. It's called design control. Whether it's a pre-market approved product or a 510K, in the medical device industry, they have to put it through a design control process where they make sure that it's going to ultimately be something they can market. And it's an internal process. They all follow essentially the same way. And in this case, that International Standards Organization standard was utilized, and it's only intended to show that it's substantially equivalent. Yes, it answers a couple of questions, which are arguably low-level safety questions, and all it talks about is, does it actually have a safe interface with tissue in general? It doesn't look at any of the issues that were actually tried. And in fact, when I questioned the witnesses, I asked them, well, do any of these standards that we're talking about here, because what they did is they rolled a library card in with 30,000 pages of documents going through that type of testing, Justice. And they said, look, this is safe. We didn't need clinical studies. And in fact, that's not the only standard they applied. They applied other standards and did what's called a clinical evaluation report, which they had to find that the devices benefits outweighed the risks on a medical basis. And what they did is, and this is again why we talked about clinical studies and why 510K is so irrelevant to the case, because the company made a choice. They could have chosen under a different ISO standard that they applied a literature review, a clinical study, or a combination of both. They chose the literature pathway only. They did that because it's the fastest, cheapest way to market. So a big part of this litigation was you made a choice based on your own design control process. Had nothing to do with 510K. It had to do with the fact that they could do this analysis with the literature move more quickly. And what we demonstrated was that the literature they actually relied on cut the other way, and they just ignored it. Articles that they relied on said that these devices and these procedures, and consistently talked to them as procedures, are unsafe. The erosion rates of 20% are too high. They looked at studies with the prior product. The Avolta Classic was the product they modeled the Avolta on. And the erosion rates and the dyspareunia rates and the pain rates were so high that the authors in those studies said that they were unsafe. The chief engineer who evaluated the dangerous properties of these products, a guy named Bobby Orr, actually looked at one of the studies for the Avolta Classic that was relied on and said that data is not a good and acceptable product. Another thing they relied on was animal studies, up to 30 and 90 days. Their vice president of clinical affairs, David Chiavarella, testified in a deposition that it would not be good science to rely on a 90-day study to project for a further period of time. We're talking about permanent devices. So those biocompatibility studies, we really tore to pieces at trial because we asked the witnesses, the expert, the design expert they brought in, Dr. Villaraga, and Mr. Darois, who was the guy who was in charge of this. Well, those studies, do they tell us if there's going to be erosion of these devices? No, they don't talk about that.
But what I read from is the 510 is the FDA's order, right?
Which I have, it's the review. I think you have the reviewer's checklist, basically, which, and I acknowledge what it says. What I'm trying to explain is that is for purposes of substantial equivalence. Every finding here is termed substantial equivalence because, look, I'm not going to say that the FDA doesn't say there's some background safety purpose to saying it's as safe as something else that's on the market. I disagree that that actually adequately protects safety. And again, even the courts that have allowed this in have said it's minimal at best. And even some courts that didn't let it in, like the appellate division said, no safety basis at all. So I'm being guided by the courts that put it all together and say it's really not ultimately about safety. Those tests were being done to say, is this enough like another device that's already on the market that can pass these tests? Not that it's overall going to be safe in its actual use. And there's actually disclaimers in the authorization to sell that say this is not to be taken anywhere beyond what it is. This is not an approval. This is not an overall finding of anything outside of the confines of what we've said. And again, the trial under the state law claims was the design medically safe and effective? Was the warnings medically safe and effective? 510K doesn't speak to that at all. However, Bard got to fully defend on the basis of what you've just read about. And again, we were able to show that none of those tests actually spoke to any of the medical issues that actually were at issue and that actually were the problems with these devices.
Go ahead.
No, go ahead.
The whole point of 510K is to say you have a new product. We have these, in your category of product, we have already decided that products like this are safe and effective. Our issue is this enough like that to say it's safe and effective? That's the whole point of 510K, right?
I think it's overstating what happened here because, again, we don't have a finding that a product was safe and effective based on a full analysis of medical risk benefit.
That's because you're saying it's not the surgical mesh. It's the hole, it's the process, it's the arms, it's the way it's inserted, it's vaginally, not abdominally, all of that, right?
That was what we tried the case on under the state law claims. And again, the question is 510K speaking to what we're actually trying? Because ultimately, you tell a jury, okay, just letting you know, this has nothing to do with deciding these claims, but just as a background point, we want you to know that this was not illegally sold. And we never claimed that these products were illegally put on the market. We said they shouldn't have been sold because they were too unsafe. But we never said they were not legally sold. It is incredibly confusing. Now a jury is saying, okay, you're telling me it was sold legally. You're telling me I can't consider it. You're telling me all these things. The appellate division said, tell the jury the difference between pre-market approval and 510K. Imagine how complicated that would be. We're talking it through, and we have to go through, and I have piles of paper I'm never going to get to on it. Imagine the thoughts it puts into jury. Why are you going to inject that level of complexity and confusion into an already complex trial that a trial judge has done a very good job of confining to the state law claims that we're trying? And it's the same.
It would be very odd if the FDA's conclusion that a product is safe and effective would completely preclude any state law claim against that product at all if the finding comes within the context of pre-market approval. And that's from the FDA preemption clause that basically says, as long as the product was found to be safe and effective within the context of pre-market approval, you cannot bring any state law tort claims against that product unless you're saying that they lied to the FDA or, failed to complete the pre-market approval process in the way that the FDA found that they did. But instead, if the product is found to be substantially equivalent to a product that the FDA has previously found to be safe and effective, not only would that not be preempted, but the FDA's finding would be completely irrelevant as a matter of law. Isn't that just very odd?
I don't think so, because again, if you look at the regulations, pre-market approval includes a medical risk benefit. It includes clinical studies to show that it's going to be effective. It includes a much more robust review, and that's why Lohr said what it said and found preemption can apply to pre-market approval, not 510K. I would say it's not anomalous. It's a recognition that 510K is here in terms of the review, and pre-market approval is here based on the regulations, and that's the reality that all of the federal courts have agreed to. Every judge that has allowed it in has agreed to that.
But Lohr was talking about, at least it appeared to me when I was reading it, Lohr was talking about when you get a substantial equivalence finding to a device that was on the market before 1976. So there is no inquiry into safe and effectiveness. And according to Lohr, it takes 20 hours and it's no big deal. You send it in, you get it the next day, and you're all good because you're the same as this grandfathered device. This case is not about a grandfathered device, right? Their predicate that they were pointing to was not a grandfathered device. Instead, it was a device that had been found to be safe and effective at some point.
I don't think that distinction actually is of any material significance here. And you can look at all of the cases that have litigated this issue in the federal courts, where every single one of them have said it doesn't matter. And in fact, the Safe Medical Device Amendments in 1990, as I said, because that's really where this comes from, this concept, have said it codified prior practice anyway. And again, I think that we're throwing the word safe and effective around, but the only way you can get a finding of safety and effectiveness if you get approved through pre-market approval, and as I'm sure you saw in the papers, it's actually a violation of federal law and constitutes misbranding to describe one of these products as safe and effective based on an approval. They're so different and there's so little done.
No, what it prohibits is saying that you have FDA approval. It doesn't prohibit you from marketing it as safe and effective.
Separately. Yeah, you're right. There is that one case. I didn't mean to suggest that you can't say safe and effective, but you can't link the safe and effectiveness to a regulatory finding.
But why is that? Is that approval? It's clearly, Bard could not sell this product without the FDA's sign off, right?
Correct.
So what does approval mean in that reg?
Well, approval doesn't.
80797.
I'm sorry, in the substantial equivalence regulation, the word approval doesn't actually appear, it's clearance.
But the reg you were just quoting to me
For pre-market approval.
It's 21 CFR section 80797, right? And that reg says,
I'm trying to find it in my pile here, but to paraphrase it while you're looking, I think that what it's talking about is it's approved as safe and effective because they do a medical risk benefit. They do clinical studies to actually prove that it is safe and effective, the particular device in question, as opposed to saying this fits into a category, so we're going to let you sell it, but we are not going to evaluate it for safety and effectiveness. And again,
I think that what it says is submission of a pre-market notification in accordance with this subpart and a subsequent determination by the commissioner that the device intended for introduction into commercial distribution is substantially equivalent to a device in commercial distribution before May 28, 1976, or is substantially equivalent to a device introduced into commercial distribution after May 28, 1976, that has subsequently been reclassified into a class 1 or 2, does not in any way denote official approval of the device. Any representation that creates an impression of official approval of a device because of complying with the pre-market notification regulations is misleading and constitutes misbranding. That's what we're talking about?
I think that's what, I believe so. That's the language that I'm certainly thinking.
What does approval mean there? Does it mean pre-market approval, as in what you would have to go through if this were classified, as it apparently now is, in terms of the slings, a class 3 device? Or does it mean what we would think of as approval, which is you can't sell this device without the FDA's sign-off?
I think that we have to take the terms as terms of art under the statutes. So, and I wish I had the language right in front of me. I'm grasping for it, which I know I have here someplace, but.
Well, the CFR, this particular portion of the CFR doesn't explicitly denote what approval means, but what it does say is a determination that a device is substantially equivalent should not be represented as approval.
Correct. And I found it, but
right.
thank you. One step too late, I found it.
So, even though we don't have a specific definition here of what approval means, we know that this CFR is saying if a device has been determined to be substantially equivalent to a device that is already in the market, that should not be represented as approval by the FDA.
Absolutely. I mean, approval is a term of art, and I'll certainly speak to the other issue that was raised on the cross petition if necessary, but that's obviously the reason why, one of the reasons why the PLA punitive damage provision doesn't apply here, because you can't call these products approved because they didn't go through pre-market approval. So that's why that provision cannot apply, along with the other terms, which again are terms of art that do not apply here. And I'll only go into that if I get an indication from the court that it's necessary. Otherwise, I'll continue to focus on 510K.
Since we're a little bit beyond the half hour already.
I'm sorry, Justice. Chief Justice.
Why don't we address a little bit of the punitive damages question as well? Is the analysis the same? Is the balancing the same with respect to punitive damages?
The balancing is exactly the same. That was actually found in the Sisson case, which actually it's the same 510K. It was the Avolta Plus rather than the Solo, but they were cleared under the same 510K. And the Fourth Circuit Court of Appeals in the case against Bard found there's no difference. The trial court found there's no difference. In the Kaiser case in the Seventh Circuit, they found there's no difference. It's exactly the same analysis, and there's no difference. What the argument is, well, there's a heightened state of mind, so wouldn't it be good to let the jury know they complied with the federal regulation to sell it? But again, that just begs the question, as the Ngayam court talks about, of what is 510K. So why would you?
Isn't that relevant to state of mind?
I'm sorry?
Why isn't that relevant to the state of mind of the manufacturer that's putting it into the market?
It's not relevant to the state of mind, and the Punitive Damage Act is very clear. It's the acts or omissions that led to the harm. The actual omissions that are at issue in this trial aren't different on a compensatory phase or a punitive phase. It's still the lack of adequate design, the lack of adequate warnings. And again, the fact that they sold this under 510K doesn't change the fact that the actual omissions at issue are only the failure to warn and only the inadequate design. So, and think about how messy that would be in a bifurcated trial. You don't let it in, and now on punitive, you say, by the way, now we're going to throw this, we're going to let you know that this firecracker might go off, there's this issue, and we're going to tell you about this at this stage. It would be even more prejudicial and more confusing. And again, the issue is exactly the same, and the trial court was exactly right to make that finding.
What's the import of the North Carolina statute? Since we're applying North Carolina law, 99B6B speaks to juries being able to consider factors that include design or formulation conform to any applicable government standard. Why doesn't that include the 510K process?
For the reasons stated by the trial judge, for the reasons stated by the appellate division, for the reasons stated by the judge in the Weinberger case, relied on by the defense and by the MDL judge, any government standard as referred to in that statute is a safety regulation, and they found every court that's looked at this, including the North Carolina judge in Weinberger, said that is not a standard of care. It's not a safety standard, so it's not implicated. 510K doesn't even fit that definition. Again, even a judge that ruled, I think we can maybe let this in with a limiting instruction. Every court agrees, and because it's not a safety regulation or standard, it's not relevant. And again, the statute says that all of the elements need not be charged. And it's similar, as Your Honor saw, it's similar to our risk utility test, and which all do not have to be charged either, depending on the proofs at the case. So that's completely inapplicable here. And it was correct not to charge under that statute.
But the federal district court in Weinberger, in fact, said it has to be admitted. It might get a limiting instruction because it's a standard. It's a government standard under North Carolina law.
That's not what Weinberger said, with all due respect. What the court said is we agree, or I agree, that it is not a government standard. It's not a standard of care, but found despite that, I think it makes sense to let the jury hear this, and I'll give a very strong limiting instruction. It's really more of a feel kind of thing to say, well, let's let the jury know how this got there. It's not that big a deal, but I think and I think the trial court recognized there was a little bit of a lack of depth of analysis in that case because the court made all these findings about the fact that it's not safety, it's not a safety standard, it doesn't fit under that statute. I'm going to need a limiting instruction, but I think I'm going to let the court hear it anyway, which the trial court here found to be anomalous. And again, at worst, it becomes a discretionary decision. And at worst, if reasonable minds could differ on how somebody decides that very, very tight issue, I think that our trial courts have to know that they're not going to be under a microscope where they're going to have to start holding 104 hearings on every single contested issue and to be concerned. I think that that's a policy point that I think this court has always felt to be very important. So I want to make sure that I'm clear on that, and you can look at the case. The judge was very clear. He agreed with Judge Goodwin, who was the MDL judge. It's not a safety standard.
I have one other question, and I hate to harken back to something we discussed before, but I think it's relevant to this issue too. If the only product or the only part of the product that was at issue here was the mesh itself, which I think you argue that's what the 510K pertains to, not the rest of this product that you were arguing at trial. If the only issue was, are the openings too big or the openings too small? If the only issue was the mesh itself, would we have a different case here? Would 510K have a different application here?
I don't think so, because all of the policy arguments and all of the legal analysis that we bring into this court from all the courts that have looked at it still are there to say 510K is substantial equivalence, not safety. I think that it would certainly be something that a court would look at to say, is it closer tied to the issues at the trial?
Mesh itself might be substantial equivalence. Forget safety for a minute. Might be substantial equivalence. Correct? That would be.
It could fit the definition, and it fit the definition here according to the FDA.
But your argument is we're not talking about pelvic mesh per se here. We're talking about a product that includes a lot of other things that make this dangerous.
Right. It was sold as a system. Exactly.
If you're talking about the other parts of the product that are used in implantation of the surgical mesh, don't you then have to deal with 21 CFR 884.4910, which I think is the FDA setting forth safety and effectiveness standards for how specialized surgical instrumentation for use with gynecological surgical mesh is used. And then doesn't it make it seem like the FDA is undertaking a safety and effectiveness analysis here?
The instruments are actually looked at completely separately, and they were class 1, where general controls were found to be at the lowest level of protection, just the tools, without context to where they were going to be used, without the fact that it's part of the Avalta. So you have them over here, which get the lowest level of scrutiny. Then you have the mesh here, which is 510K, and all they are is the delivery system for a medical procedure this company is now selling, which is what actually was sold by the company and promoted by the company. For example, to Dr. Barbie, who actually went to a training session. Bard, like all medical device manufacturers, runs professional education where the sales representatives invite doctors and say, let us teach you our procedure, which is competing against the Prolit from Ethicon and the American medical system's Apogee and Perigee. And our system is different. It's put in differently. It anchors differently. It's more simple, it's more intuitive, and that was where the competition was. And again, so it's not that the FDA looked and said, well, these instruments with this mesh, with this procedure, it's safe and effective, pre-market approval. It doesn't, none of that happened. And again, the instruments were looked at separately out of context.
So this classification where it says class 2 special controls, the special controls for specialized surgical instrumentation for use with urogynecologic surgical mesh are, and then it sets forth the special controls, that is not related to a class 2 safety and effectiveness inquiry?
To the extent that a surgical tool was classified as staged as a class 2, that's actually not this case, because these surgical tools were class 1.
Got it.
But even if the tools were class 2, we would still be in a 510K situation and still have the same problem where, again, and I know that I've said this several times, that's not what the jury was considering. The jury was considering safety and effectiveness on a medical risk benefit, which the witnesses for the defense could not deny and had to admit that's not something that they could really answer with the literature they relied on, because all the literature was saying, very dangerous, don't use these devices, we need long-term studies, we need more data. I mean, that was their own studies. I gave you in the record a Mayo Clinic article that they didn't consider, but my expert said, how do you not consider this? That said, these new kits, they were called kits, that's what they were being discussed by the urogynecologists, are so dangerous because the Mayo Clinic was seeing cases from all over the country, as they do, and they were seeing these massive complications, and the pictures are very graphic, and the article is very graphic, but the bottom line, they said, until there's level 1 evidence proving safety and superiority to the other alternative procedures that exist, these should not be available for widespread marketing. I mean, that's literally our argument to the jury, and 510K doesn't speak to that at all, and that is one of our crowning pieces of literature, the Mayo Clinic saying you can't do what you did. You can't, and that came out before her surgery. And I'll tell you another issue about the clinical studies. The standard in North Carolina, just like New Jersey, is what they knew or should have known. So why would we not talk about the clinical studies they never did? That's the should have known in the medical device and drug industry. The way you know things is you do clinical studies.
Nobody's saying you wouldn't talk about that. The only issue we're deciding is whether there's some other evidence out there that it should have at least been considered by the jury in reaching its conclusion. Nobody's saying that stuff doesn't come in, that stuff's not relevant, that may be enough for the jury to decide you win. The only question is whether this 510K evidence comes in for that limited purpose.
I think what I was trying to say, not eloquently, was that the 510K doesn't answer that clinical study issue in the trial, and that so the suggestion by the appellate division that, well, you talked about clinical studies before the 510K decision, this is a very important point, before it ever happened, a year or more, however long before, the expert reports were written and we took the depositions of the experts. These issues were already in the case. This was not the clinical studies issue.
And that's all evidence, and that's all going to the jury, and that may all prove your entitlement to damages and punitive damages. The only question is whether in that context, in that trial, the jury should have had a chance to hear that there was a process that it did go through to get into the market. That's all that question is. It doesn't exclude anything else. It doesn't even mean that that evidence trumps anything else.
I was sort of answering the point of did I take advantage of the ruling by talking about clinical studies? I just wanted to make sure that that notion was disabused.
I don't think that's the question, taking advantage of clinical studies. The question is, when you say, if you say, I have to look through the whole transcript again, but if you say that the FDA never considered, the FDA never looked at, the FDA never thought of, then you might have a problem.
Well,
and then it may come in just because you raised it.
Well, of course, I stayed miles away from that.
No, but that's really the question. You're getting into another area.
I think that my best response to that is this. We already had two very complex issues at trial, the design claim and the failure to warn claim. It took a month to try this case with very sophisticated law firms on the defense side with a lot of experts. If you inject 510K into this trial, that becomes the third major issue in the case, because there's no way to get away from it. And I will tell you, from my perspective, the idea of a limiting instruction would be devastating. If it comes in, you have to have a mini trial on it because it's so prejudicial to tell a jury that the FDA allowed it to be sold. Now the jury has to understand. Now they're hearing proofs on both sides, and you've now elevated this issue to another litigated issue in the trial. There's no way around it. I can just tell you, trying these cases.
Back to something, because I just really should stop here. But the FDA said the mesh can be sold. The FDA never said, at least I think your argument is, that this product can be sold. That's why 510K is not relevant.
The FDA never looked at the procedure, never did a medical risk benefit, correct?
Wait, but the FDA never authorized the product? I thought the FDA had authorized the product.
No, what I'm saying is the FDA didn't consider the procedure. They didn't consider the medical risks and benefits. They didn't look at how is this going to go in the body, what's it going to do to the body, how's it going to harm a person.
You might disagree with the FDA's analysis, but they did, at the end of the day, send some sort of order that says, yes, you can go ahead and sell this.
I'm not disagreeing with the FDA's analysis. What I'm saying is the analysis, as every court that's looked at this, including those who have let it in, is that the analysis is so minuscule that it's so that and even the courts that let it in have acknowledged the confusion and prejudice it would inject. That's what I'm saying. I'm not saying the FDA was wrong. I'm not saying they didn't consider what they considered, but they didn't consider the issues that we were going to try the case on. And I think that the better practice is if a trial judge looks at all of this and says, look, I know this case. I know how it's going to be tried. I'm going to keep the issues confined, not only keeping out 510K, but the flip side of the coin that they stopped selling these products and why they stopped selling these products. We're not going to try the case on that either. We're going to focus on the state law claims at issue, and we're not going to have these other sideshows because the case is already tough enough. I think we have to respect the trial judge's discretion in making that decision.
Let's pause there for a second. Anybody have any additional questions? Anything you'd like to add? We'll have you back for rebuttal, of course.
Thank you very much.
Mr. Pasatella.
Good morning, Your Honors. Thank you for permitting NJCJI for the opportunity to appear and argue today before the court. The 510K pathway does not evaluate a specific medical device's safety or efficacy. So it is therefore irrelevant and inadmissible to a design or warning defect claim under the New Jersey Product Liability Act or a claim for punitive damages under New Jersey law. The appellate division here wrongly substituted its judgment for that of the trial judge, who carefully considered the factual record and came to the correct decision, which was consistent with every court of appeals that has considered this issue. And those appellate courts have explained that to permit 510K evidence would create an extensive mini-trial irrelevant to the central questions posed before this court, whether the device at issue was defectively designed, contained a warning defect, or whether punitive damages were warranted. 510K clearance is irrelevant to a design defect claim under the New Jersey Product Liability Act because the Product Liability Act focuses on the product, strict liability focuses on the product itself. The Act requires that the jury do a risk utility analysis to determine whether the product is defectively designed, and thus if the manufacturer acted reasonably in marketing the product.
But isn't the substance controlled by North Carolina law?
The substance in this case, the underlying is controlled by North Carolina law. To the extent that it may be relevant, and this court would like to provide guidance to New Jersey courts on how to address this issue moving forward, we address New Jersey law in light of in reaccutane, which, as after every case from this one, it'll be New Jersey law. So therefore, it's important to recognize how New Jersey law handles 510K. The risk utility analysis that involves a severance factor test under the New Jersey Product Liability Act, and notably, compliance with any federal regulation, including 510K, is not part of those factors. And that makes sense because, as the appellate division here and the Supreme Court in Regal explained, the 510K clearance process does not require a device to take any particular form for any particular reason. 510K is also irrelevant to a warnings defect claim under New Jersey law, because as this court has explained multiple times, safety is the predominant factor in determining the adequacy or reasonableness of a manufacturer's efforts in a warning defect claim. The reasonableness of a manufacturer that the jury is tasked to evaluate in a warning defect claim is the manufacturer's decisions of whether and how to warn, not whether it was reasonable to subject its device to a substantial equivalence test. And going back on the discussion that you had with Mr. Slater, is that under our law, as stated in Becker, Feldman, and O'Brien, this court has emphasized that whether a product is defective must focus on the specific product at issue. And you rejected a categorical approach to safety. But the 510K pathway only follows that rejected approach. According to the United States Supreme Court in Regal, 510K does not evaluate if the specific warning communicates adequate information about the dangers and safe use of the individual marketed device, and it does not require a specific labeling requirement for the individual device. 510K asks only whether the medical device falls within the same the category as the predicate device, not whether the specific product device that's marketed at issue is safe. 510K clearance is also irrelevant to punitive damages under the Punitive Damages Act.
So back to liability for 1 second. I thought that you had stated in your brief that FDA evidence could be relevant to a strict liability tort claim only if it was about safety and effectiveness, and only pre-market approval is about safety and effectiveness, not 510K. But I thought that under Lohr and Regal, all state common law claims, including a strict liability claim, are preempted if the device received pre-market approval. So I wasn't sure, when would an FDA pre-market approval finding of safety and effectiveness ever be relevant to a state law claim if all state law claims are preempted as soon as you have such a finding?
Well, a design defect claim would be preempted, but the Product Liability Act allows for rebuttable presumption if a device is prescribed or approved, and that is not 510K. 510K, the market devices that are approved are only those that are past pre-market approval. And that's because, as we discussed earlier, it would be criminal misbranding for a manufacturer to say that its device was approved when only it passed 510K. And warnings that pass 510K are not prescribed under the Product Liability Act because, as the Supreme Court explained in Regal, only pre-market approval imposes warning requirements to specific products to ensure that the product is safe and effective. 510K clearance does not. Turning to punitive damages, 510K clearance is also relevant to punitive damages because, as the appellate division correctly recognized, 510K clearance is not one of substantive pre-market approval or licensure, and does not signify the FDA has found that the device to be safe and effective. So it does not fall by the clear text of the statute does not fall within the absolute defense to punitive damages. And given that the legislature has addressed pre-market approval and licensure, but not 510K clearance, shows its intent that 510K is irrelevant to punitive damages.
Again, this seems to run into the same issue as before. So if only products that have received pre-market approval can fall into this punitive damages statute, but all products that have received pre-market approval, you can never bring any state law claim against them because all state law claims are preempted by the FDA's regulations, then are we just saying that the New Jersey law reaches absolutely nothing because it could only reach devices that have received pre-market approval, but if the device has received pre-market approval, then all state law claims are preempted?
Well, we have to look at the specific text of the statute, and that would be where we start with our interpretation of the PLA. The PLA for the punitive damages says that there's an absolute defense to pre-market approval, licensure, and those devices have been, products have been generally recognized as safe. That is not 510K. So it's irrelevant by the clear text of the statute to punitive damages.
So then the statute would, though, reach nothing, no devices, at least.
Well, if you have a rebuttable presumption that, you meet the rebuttable presumption on a failure to warn claim and you get to punitive damages are allowable. So, I mean, if the clear text of the statute is what it is, and not only is the clear text of the statute not reach 510K clearance, but the fact that the manufacturer's device received 510 clearance is also irrelevant because under the Punitive Damages Act, the jury must consider 4 factors in deciding whether to award punitive damages. All of those factors are based on the defendant's knowledge of harm that would arise from its conduct and its response to that knowledge. 510K clearance is irrelevant to that question. Finally, I'd like to discuss the practical implications of permitting 510K evidence. To follow the appellate division's framework would substantially confuse the issues for the jury and create a mini-trial over the efficacy of the 510K pathway, what it entails, and whether the predicate device, which is not even the device at issue in the case, is safe. This could easily inflate the perceived importance of 510K compliance and distract the jury from the central questions that it is tasked to answer. As the Fourth Circuit stated in Sisson, it expressed its concern that possibly days of complex testimony about regulatory compliance could lead jurors to conclude that regulatory compliance proved product safety. Here, Bard proffered that if the jury were permitted to be informed about 510K clearance, it would have called 23 witnesses to address 510K in what was already a 4-week trial. Then, presumably, the plaintiff would be forced to respond with their own experts and witnesses. So practically, permitting 510K evidence would unnecessarily and substantially risk that the jury would confuse the issues at hand and significantly prolong what are already complex trials.
The trial judge could control all of that, can control the number of witnesses, could control the length. You see that it's somewhat difficult to argue prejudice from the side that has got a very large verdict?
Well,
multi-millions?
I don't see that as the issue here, Your Honor. The issue is if 510K is admissible in a case, that changes the entire nature, complexity, perhaps outcome of a trial. Because once you put FDA clearance, FDA anything on the table, that changes the balance so much.
Aren't you making their argument? That's right. The jury should consider it.
I'm not making that argument, Your Honor. I'm saying that any tangential relevance which we submit there are none, because the evidence of 510K clearance still needs to be relevant to a particular claim or tied to an issue. In this case, it's not. Any potential relevance, if you were to find some, is so substantially outweighed by the danger of undue prejudice that the imprimatur of FDA clearance approval would weigh on the jury, would tilt against it being admissible. And a limiting instruction cannot cure that prejudice.
What if a court were to determine that it was relevant just to the punitive damages phase of the case? Is the prejudice the same?
It is, Your Honor, because it's once FDA approval is on the table, it skews the jury's perspective into saying that the FDA found that this device was safe. But to punitive damages, that's irrelevant, because the punitive damages asks only the 4 factors in the Punitive Damages Act is what was the defendant's knowledge and what was his response to knowledge. Once FDA clearance is injected to that question, it skews away from those issues.
I can't tell if your argument is that the jury would not follow instructions from the judge explaining that this is not determinative of the case and that this is not a finding that is the same as a pre-market approval finding. Is that your argument? Or is your argument that the FDA approval actually is, or even the FDA 510K actually is really important, and so the jury would properly consider that it is?
My argument is kind of both. It's that the FDA clearance could take such a weight that it would distract the jury from considering the true issues that is before the court. And before the court are issues related to warning defect, design defect, and punitive damages. Nothing of the elements of those claims fit with 510K clearance. So once you inject 510K clearance, it takes on a whole new importance that is really irrelevant to the claims at issue.
But at trial, there was discussion of a lot of the underlying, even if there was not a mention of the 510K clearance process, it seems like there was a discussion, your friend mentioned, about a lot of the evidence that went into the 510K clearance review or the 510K, even their order, I think, what was specifically mentioned in the FDA order, I think your friend was saying was part of the trial. So the jury heard all of that, but you think the fact that the FDA had any process would be so prejudicial. Doesn't that itself mean that the process was relevant to the case?
It doesn't, because 510K, the Supreme Court has said in Regal and other court, the Fourth Circuit, the Sixth Circuit, every appellate court that has considered the issue has said that 510K does not go to safety. If 510K...
Again, Regal considered the 510K process to a pre-1976 product, not to a product that was held to be safe and effective.
Well, the Sisson, the Fourth Circuit, the Sixth Circuit, the 11th Circuit have all found that 510K clearance, including those courts that consider products that are the ones at issue here are very similar, is not relevant to safety. This would be the first appellate court to find so. So because 510K clearance does not go to safety and only goes to substantial equivalence, it's irrelevant to the questions that the jury needs to answer.
Thank you, Mr. Plastow.
Thank you, Your Honor.
Mr. Cobb.
Chief Justice Radner, I have a 5-minute opening, but may I also reserve 3 minutes for rebuttal?
Yes, and rebuttal would be limited to the issue on the cross appeal of punitive damages.
That's my understanding, Your Honor.
Please,
thank you.
Go ahead.
In both New Jersey and in North Carolina, the standard for defect in a product liability case is whether the manufacturer acted reasonably in designing the case and in formulating the warnings. And in this case, the parties stipulated, as Chief Justice had noted, that on the product liability case, the North Carolina statute would apply. And that North Carolina product liability statute expressly incorporates the standard I just gave, whether the manufacturer acted reasonably in designing the product and in formulating the warnings. But the North Carolina statute goes further. And it lists a number of risk utility factors, and it says the trial court shall is the verb, instruct the jury on, and then it lists the risk utility factors, and it says any government standard. There's only one North Carolina decision, and that's Weinberger. It's a pelvic mesh product liability case. It's directly on point, and it holds that 510K evidence is admissible under the North Carolina statute. I'm going to drop a footnote. Just like this court, on 3 occasions, Feldman, Kendall, and Perez has said FDA evidence is admissible in a drug and device case. At trial, on 23 occasions, the plaintiff's lawyer referred to the lack of clinical trials. He said clinical trials were necessary and required. He even said that because these products were not subject to clinical trials, that they were experimental. And Bard's hand at trial were tied. Bard could not tell the jury that under the federal statutes, it had to use the 510K process. It could not use the pre-market approval process. Bard could not tell the jury that it went to the FDA, asked for permission to sell the products. The FDA gave it permission, and in doing so, said to Bard, but you must change the warnings, and Bard did that. And most significantly, Bard could not tell the jury that the FDA specifically concluded that no clinical trials were required. And as Judge Sabatino noted in the appellate division decision, this left the jury with a false impression that there was no regulatory oversight at all of these products. On punitive damages, the parties stipulated New Jersey law would apply. And New Jersey law on punitive damages is well settled. The 2 primary factors are the defendant's state of mind and the defendant's conduct. You reaffirmed that recently in Rivera versus Valley Hospital. And here, all of that 510K evidence that I referred to before is clearly relevant on the defendant's state of mind and the defendant's conduct. Let me switch gears to the Section 5 issue. And the legal issue for the court on Section 5 is when the legislature used the words approved, licensed, and generally recognized as safe, did they intend those words to have the words of art of the federal statute, or did they intend that they would have ordinary meaning? And the answer to that question is within the wording of Section 5. The last sentence of Section 5 says that the words drug, device, food, and food additives shall have the word of art meaning of the federal statutes. It does not say that as to approved, licensed, or generally recognized as safe. Finally, on the Section 5 issue, the court, in our view, needs to also heed Section 1 of the Product Liability Act. Section 1 of the Product Liability Act does 2 things. First, it says the court shall, again, the verb is shall, consider the legislative history in interpreting the act. Here, both the Assembly statement and the governor's past bill memorandum specifically say that Section 5 applies to products that are regulated by the FDA, and everyone in this case stipulates these products are regulated by the FDA. The other thing that Section 1 does, and I've not seen this in a statute, the very first sentence of the Product Liability Act says that the legislature finds that there is an urgent need for remedial legislation, especially as it relates to punitive damages. So, if you apply the words of Section 5 or you do what the legislature instructed you to do, which is to consider the legislative history, to us it is an inescapable conclusion that Section 5 applies to products that are cleared under the 510K process by the FDA.
Are you done with your opening statement?
Yes, sir.
On the first question, let's start on the issue of the standard of review here. We have a thoughtful analysis and opinion at the trial court level, thoughtful one at the appellate division level. Did the appellate division substitute its judgment or abide by the abuse of discretion standard?
So there's it's an academic question here, Chief Justice. We contend that it's a de novo review because the trial judge refused to instruct the jury on the North Carolina product liability statute. We asked for a jury instruction consistent with the risk utility factors and consistent with reasonably, did a manufacturer act reasonably, right out of the statute. The trial court declined to do that, and in doing so, in part, he relied on his interpretations of the federal statutes and regulations. So we contend it's de novo. The reason, Chief Justice, I say it's a nice academic question is because assuming that it's an abuse of discretion standard, there was an abuse of discretion standard here because there was a manifest denial of justice because of the mantra by the plaintiff's lawyer on the lack of clinical testing, which we could not rebut, and also because the trial judge's discretionary ruling was based on an impermissible reading of the law. And this court has said in a few decisions that even if it's an abuse of discretion, when it's based on an impermissible reading of the law, it's not entitled to any discretion.
So if you're arguing that the trial court judge's decision was based on an impermissible reading of the law, does that mean that you're asking us to hold that 510K evidence must be admitted in every case so as not to deprive defendants of the right to a fair trial?
Yes, well, two reasons. Yes, not to deprive the defendant of a fair trial, but beyond that, because it is relevant to the standard, be it North Carolina or New Jersey, did the manufacturer act reasonably in designing the product and in formulating the warnings?
I heard you say in your opening that you had to go through the 510K process and that BARD could not go through the pre-approval process. Why is that?
Yeah, the reason is because, and in some of the colloquy with Mr. Slater, in the mid-1980s, the FDA convened 3 scientific panels of physicians, scientists, and others, and they recommended that surgical mesh be placed in Class 2. And in 1988, the FDA placed surgical mesh in Class 2, which under the federal statutes, they could only do if that ensured a reasonable assurance of safety and efficacy. To answer now the question, under the federal statutes, once surgical mesh is put in Class 2, the only avenue available to the manufacturer is 510K. The manufacturer cannot use the pre-market approval process.
Mr. Slater's arguing that it's not just the mesh, it's the tools, the process where these arms are anchored, that makes this a new product. Why couldn't you have gone under a new product and not gone under Section 2 approval?
Well, the first time I think I'm hearing that argument by Mr. Slater all through this case, meaning the appellate division, the trial court, is today. But to answer your question, Your Honor, the devices, the tools, also are subject to government regulation.
Right, as a class 1.
As a class 1. And we had approval to sell them. If his argument, now I'm going to lapse over to the other, if his argument is, well, it's class 1, that's the least regulated of the, I'm not sure I'm answering your question, Your Honor.
You couldn't decide that this is a new product? I looked at the guidance. I thought one could say, we're using mesh, but this is actually a completely new thing.
Okay.
And come in as a new product.
Yeah, I'm not sure I know the regulatory answer to that. However, when we look at the entire trial record here, there was no complaints over here about the tools. The entire complaint was the mesh, pore size, other aspects of the mesh. That's what the entire trial was about, not about the tools that were used.
What are we to make of 21 CFR 807.97, which says a finding that a device is substantially equivalent to a device already in distribution does not in any way denote official approval of the device?
Right, and that is a regulatory requirement of the FDA dealing in marketing. Your Honor, I don't think that has anything to do with the evidential questions here. I'll concede, we will not argue a trial if we get a new trial. We're not going to say that it had approval, but that doesn't really answer the question of whether the trial court properly excluded this evidence. And I would add, does not answer the question under Section 5, where the word approved is used, because in Section 5, we're looking at the legislative intent, not what the FDA in Washington, D.C. did.
So you would argue that your product was approved pursuant to Section 5, but was not approved pursuant to the FDA regs?
Our argument is specifically that the word approved in Section 5 should have its ordinary meaning, not its word of art meaning in the federal statutes. And when we look at the dictionary, approved, it's a sanction to do something. And we clearly, no one questions here that the FDA gave us permission and allowed us to sell these products.
So you would have to agree with Mr. Slater that the appellate division opinion is inconsistent.
Well, particularly in one part. I don't know. I agree with Mr. Slater on this. He said in his reply brief on the certification, there's no need for a 104 hearing because there was a massive offer of proof by board, which there was. So what are we going to do, essentially? I'm putting it in lay terms in a 104. So I agree with him that, Mr. Slater, that we don't need a 104 hearing. What I don't think the appellate division is saying is that ultimately the trial court could exclude the evidence. For the reasons I've said before, 510K evidence is always relevant, even if we try the case under New Jersey law, is always relevant on the reasonableness of the manufacturer's design decisions and warning decisions. If we have a 104 hearing, maybe the issues are time limits. Maybe the issues are what can we say, meaning can we say approved? No. Maybe the issue is, hey, counsel, how do I deal with this limiting instruction? What does that do? So in this case, we don't think a 104 hearing is needed. However, if you're asking me, now I'll be a friend of the court, broader in these cases, I don't know that it's needed. I think I'd leave that to the discretion of the trial judge, the way 104 hearings are normally left to the discretion of the trial judge.
You agree that the jury could not be told the product was approved?
Yes, I absolutely agree with that because that would be untrue.
And yet that raises a question about whether there's tension with the reading of Section 5 that you're advancing, which uses that term as well.
Yeah, because we're doing different things. In Section 5, we're looking at legislative intent. on the first part, what the jury could be told, we're looking at the rules of evidence. And what I'm saying is, yes, we cannot tell the jury under the rules of evidence that it was approved. But when we move over to Section 5, approved is not a word of art under the federal statutes. It's its ordinary meaning.
Right. And isn't it the ordinary meaning of the term approved that you conceded there would be a concern in presenting that language to the jury?
No, the reason I conceded that is because under federal law, we cannot say that. I would be, if I were trial counsel and I turned to the jury and I said approved, I would be violating the federal law.
The court in Weinberger allowed the 510K evidence to come in with a limiting instruction that said that the 510K clearance process is not to be considered as evidence that the FDA authorized the product as safe and approved its intended use as such, that the 510K clearance is not evidence that the defendant satisfied any standard of care in designing the device, etc. If a similar limiting instruction were to be used in this case, what would you want the evidence in for?
On the reasonableness of our conduct, both in terms of the product liability claim and punitive damages. And Your Honor, I would just say this, as Mr. Placitella had noted, this case will be retried if it is, depending on the ruling of this court, under New Jersey law. And I call this court's attention to model jury charge 5.40D42, 5.40D42, which is a specific jury instruction, a limiting instruction on what the jury does with FDA evidence. And I'm going to paraphrase it very quickly. Basically, it says, you heard FDA evidence. That is one factor here for you to consider. It's not determinative. You still can find the product defective, even though the FDA cleared it. So I would call the court's attention. Again, I paraphrased it. It might need to be modified somewhat, but it gets the trial judge to the 20-yard line on what the limiting instruction should be.
The federal reg that prohibits you from saying that the 510K is an approval, that I think was adopted in 1977. Our Punitive Damages Act was adopted 10 years later. Right. Why wouldn't we think that they knew that and they used it that way?
Well, because I don't think in determining the legislative intent, we look at what the FDA did, and we know what the legislative intent is here from the history, the legislative history. I incorporate by reference what I said before. Section 1, the Assembly statement, and the governor's past bill memorandum say all those terms, what we're talking about is regulated.
Help us, please go ahead.
If the court were to agree with you that 510K evidence is admissible, then plaintiffs would be permitted to introduce evidence that the FDA eventually reclassified pelvic mesh as a Class 3 device requiring pre-market approval, right?
No, I don't think so. Early in the appellate division decision in this case, Judge Sabatino, and he's got a couple sentences on that, refers to Evidence Rule 407. But more importantly than Evidence Rule 407, the reason that would not be allowed is under the North Carolina statute, and it's the same thing in New Jersey, whether or not a product is defective is determined at the time it left the control of the defendant. So putting aside Rule 407, just relevance, it would not be relevant that a number of years later, the FDA reclassified one of the two products.
Can you parse for us the language in Section 5 and tell us which of the three areas you are relying on?
We approved, using the definition of approved that I said before, we believe this product was approved to sanction. Licensed, which this court has recognized in other statutes, the Administrative Procedure Act, the legislature is defined licensed as permission to do something otherwise illegal. And generally recognized as safe, and I need to explain how I get there.
Question about the first prong before you get to the third. Was this approved under the Food and Drug Administration, under the Federal Food, Drug, and Cosmetic Act?
The answer is yes, and the statute in Section 5, what Your Honor is referring to, under the Federal Food, Drug, Cosmetic Act, it says et cetera, which drags in the entire act, which would drag in cleared devices. And if we're correct, Your Honor, that approved has a ordinary meaning, then the products were clearly approved.
But were they approved under the FDCA?
Yeah, yes, because the FDCA, it says, again, et cetera, which drags in the entire act. And I would also come back to
And therefore, finish that clause.
And therefore, it includes, again, in our view, anything that is approved is sanctioned to sell.
But again, going back to the regulation, so you're arguing that under the Food, Drug, and Cosmetic Act, this device was approved. But when we get to the regulations, the definition of approved in that regulation that says this cannot be marketed as having been approved is a different definition.
Yeah, I am. And part of the support for that is the last sentence. Now I'm going to come back. The definition of drug, device, food, and food additive is the same definition as in the federal statutes. Well, the federal statutes contemplate devices go through the 510K clearance process.
What about the first sentence of the act where it says punitive damages, before it says, and was approved or licensed? It says punitive damages shall not be awarded if a device which caused the claimant's harm was subject to pre-market approval or licensure by the FDA under blah, 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 and was approved or licensed. So doesn't the word and was approved mean under pre-market approval because a few words before the statute said was subject to pre-market approval?
I think, but I'm not sure, Your Honor, and the question may be assuming that we're not using the ordinary language of Section 5. But
I'm just referring to the words where it says was subject to pre-market approval, and then it says under the various laws, and then it says and was approved. So I understood your argument when you were saying the word approved, had it not previously, a few words before, said was subject to pre-market approval. I would understand your argument that the word approved is subject to, it doesn't mean by under the FDA definition, it means under general, under the general meaning of the word. But because a few words before it says was subject to pre-market approval, I'm just not sure, are those words just struck from the statute? Do they not have any relevance?
no, I think because they incorporate the federal statute in that area because they need to put a boundary on what they're talking about. But again, the question, I think the legal issue is, did they intend to have those words have the word of art of the federal statutes?
But assume that they just get common, ordinary meaning.
Right.
Isn't there a difference between pre-market approval and clearance, a clearance process?
There is.
And yet, this language, the ordinary term used is pre-market approval and approval.
Right. And I don't know that that answers the question because, again, was the legislature using those terms, ordinary terms, which from the legislative history it looks like they were, or was the legislature using them as terms of art? And when we look at the last section of Section 5, the last sentence, it's clear they did not intend those terms to have the word of art. And Chief Justice, if I could come back to generally recognized as safe.
I'm going to encourage you to.
Thank you. As the colloquy with Mr. Slater, in 1988, when the FDA put mesh in Class 2, under the statutes, they could only do that upon a reasonable assurance of safety and efficacy. And the other thing I'd encourage the court to look at is the record in this case. We obtained from the FDA their files through the Freedom of Information Act request. And a line appears in the appellate appendix at 2426 and many pages thereafter, Avulta 2595. And in the FDA's own documents, it's loaded with safety information, but also, Chief Justice Rabner, there are a number of places in there, and on page 18 of our brief in opposition to Mr. Slater's cert petition, we have pinpoint sites, a number of places in the FDA's own file where they say, as to these products, they are safe and effective. So, assuming for a moment that the court disagrees with me on approval, disagrees with me on license, when we look at what the FDA did in 1988, classifying the products in class 2, and when we look at the record in this case, what the FDA said about the two products, it also meets generally recognized as safe.
Haven't a number of federal cases said 510K does not establish approval or licensure?
Yeah, actually, Justice Solomon, I think if you look at all the federal cases, most of them exclude 510K. Most of them start by saying it's probative, but then they exclude it under 403. And Rule 403 is very record specific. And when I look at those cases that excluded it, we don't have the no clinical testing argument made by the plaintiff here. And what's most important on that question,
I'm just sticking to the narrow issue you raised, that it is somehow, it is approved or licensed under Section 5 of the PLA. And I'm saying, yeah, but haven't a number of federal cases said, no, it's not?
Well, and what I was going to add, Your Honor, is a lot of those cases, the arguments we make here were not made to those courts. In fact, the 11th Circuit decision in Engelheim, footnote 3 specifically says, defendant did not argue, and then it's everything we argue here, so we're not going to consider it. In the last 3 or 4 years, a number of manufacturers have made the arguments we make here, and the clear trend around the country among federal judges, despite 3 circuit courts, the clear trend is to admit the evidence, and a lot of those cases say it's probative, meaning it does go to...
Does it say they're approved or licensed?
I'm sorry, Your Honor.
Does it say it was approved or licensed?
No, it does not say approved.
Okay. I mean, I understand your argument that it's generally safe and effective. I get that.
Yeah.
But I don't get the argument that it is licensed or approved by the, because a number of federal cases under the applying the FDA have said 510K doesn't say that.
And again, many of those federal cases, the argument that we make here, the very arguments we make here, were never made in those cases.
Okay.
Does the 510K process, as you understand it, directly address safety and...
Yeah, it does, Chief Justice. There's a lot of briefing on this, but when you look at the federal statutes and the federal regulations, it is clear that the clearance process involves safety. And beyond that, Chief Justice, the FDA has said, and they've said it clear as a bell 4 or 5 times, that in every 510K review, they consider safety and efficacy, and so has the U.S. Supreme Court.
So the FDA, in its guidelines on the 510K program, speaks of the process as a comparative one, not one that directly assesses safety and effectiveness. Have I misunderstood that?
Yeah, I read some of the FDA guidelines differently. I don't think they're saying it's just comparative. I think what they're saying is we do look, and the word every is there, in every 510K process, we look at safety and effectiveness.
So my question is, does it do so directly? It states, of course, and we understand, that safety and effectiveness underlie the process, but does it make a direct determination of safety and effectiveness?
Looking at the record in this case, it surely did. That's why I gave the sites to where the FDA records were, because they were looking at biocompatibility. They were looking at huge number of tests unrelated to comparative. But even if we assume comparative, and I'm going to come back to an earlier colloquy, we're comparing them to products that had previously been cleared by the FDA and products that had been out on the market.
But there is no independent determination with regard to the new device, whether it's safe and effective. To follow up on the Chief's question, the guidance says, although the 510K process involves a comparison of a new device to a predicate device rather than an independent demonstration of the new device's safety and effectiveness as required for approval of a PMA.
Yeah.
It's making a clear distinction between PMA approval that is focused on safety and effectiveness and the 510K process, which is not. And we've discussed this already. There might be safety underlying, but that's not the focus of the 5K determination. The focus is this the same as this other device on the market?
And Justice Pierre-Louis, the comparative process is safety and effectiveness for the reasons I said a minute ago, which is they're comparing it to products that are out on the market, where they're aware of what's going on with those products. I mean, products out on the market are better than clinical trials. They're in clinical use by physicians and hospitals.
Is that true even for products that were on the market before 1976?
No, I do not know the answer, but I don't think so, Your Honor.
What do we make of those? Comparison. Oh, I'm sorry.
Please go ahead.
But again, it's a comparison. And with each different device, there's different materials that could be used, correct? Here, Bard was using a material that it was aware should not have been used for permanent implantation inside the human body, correct?
Well, that's the claim of the plaintiff.
Right. But there was some testimony with regard to what Bard had been told by the manufacturer of the product.
Right.
How that product should and should not have been used, and the fact that Bard nevertheless used that material.
There was some evidence to that.
So
effect.
in the technological characteristics portion of the 510K determination, that comparison is driven by what the manufacturer tells the FDA with regard to the technical aspects of the product to determine whether it's similar to this other device that's on the market, and again, whether it's generally safe and effective. But if information is not presented in the same manner that it was presented from the manufacturer here, there's no way during the 510K process for the FDA, there's no check with regard to whether the specific device and all the materials that are being used is safe and won't cause any harm.
It's not only what Bard told the FDA. Bard gave the FDA biocompatibility testing and a whole variety of other testing on the mesh material. So the FDA had testing on that as well.
What are we to make of the FDA's amicus filings in the circuit court, where the circuits have relied on amicus filings where the FDA says we're not doing a safety review in a 510K, in essence.
And those amicus filings are out there, but they're also inconsistent with what the FDA has said in their guidances. And there's something interesting about the guidances. In the Safe Medical Device Act of 1990, when the Congress beefed up the clearance process, the Congress instructed the FDA to put out guidances as a control. So the guidances here are put out by the FDA because the Congress told them to put out information on your process. So I acknowledge there is some inconsistency in amicus filings. I'm not sure I'm right on this, Your Honor, but I think the issue there was not admissibility of the evidence, and did this defendant get a fair trial I think that was on other issues.
Other questions, anyone? Anything you'd like to add, Mr. Cohen?
Yes, briefly. This court has said on 2 or 3 occasions that the hallmark of our civil justice system is fairness. And that's reflected in your case law. One example is opening the door, which clearly applies here. But it's also reflected in Rule 1:1-2 of the court rules. And most importantly, it is reflected in Rule 102, Evidence Rule 102. And any fair reading of this record would show that Bard did not get a fair trial. And therefore, we ask this court to affirm the judgment of the Appellate Division, vacating the judgments rendered against Bard below.
Thank you. To the 3 amici we're about to invite up, I'd ask you to plan for no more than 10 minutes for your presentations. Mr. Rogers.
May it please the court. Thank you for allowing us the privilege of participating in the oral argument today to present some views on behalf of my clients, the amici. We're here to help the court better understand the 510K process and to also understand why the Appellate Division got this one right and correctly held that this is evidence that should be admissible in products liability cases, particularly products liability cases like this that involve punitive damages. Now, the 510 clearance process is an especially important part of the comprehensive federal regime for regulation of medical devices that has 2 primary goals, right? The first primary goal, providing reasonable assurance that medical devices are safe and effective. And the second is encouraging innovation and patient access to those needed medical devices. The 510K pathway through which the medical device industry brings to market the vast majority of devices that are needed for patient health to save people's lives. This pathway requires that manufacturers for certain devices, that manufacturers use the judgment of the federal agency that they said they have to go through this particular form because that particular form will provide reasonable assurance of safety and effectiveness, but it would also ensure that we get needed therapies to the public faster when the FDA and science has determined that you don't need to go through the more expensive, the more robust, and the more time-consuming process that's involved in pre-market approval.
Does that apply also when you're arguing that the predicate device was in use for sale before 1976, or is that only for devices sold after 1976 that they have a finding of safety and effectiveness?
Your Honor, it primarily is the latter. If you look at what the FDA has said, they're pretty much done with that grandfathered exception. They've gone through the reclassification process of all of those devices. Pretty much, I think by a couple of years ago, maybe there were only 25 left, and now they're pretty much done. So that really isn't part of the 510K process even today. But
does that explain then the statements from the Supreme Court in Lohr and Regal from the 1990s? Talking about how, at least in both of those, in Regal, they really just cite back to Lohr, but in Lohr, they're talking about a case that had been sold pre-1976, and so they say, this has absolutely nothing to do with safety. This takes 20 hours. This is no big deal, and it's just about being able to sell the device so that you can compete with someone who is already selling it.
Absolutely, Your Honor. That antitrust-related exemption that exists when the medical device amendments were passed in 1976 was particularly for that purpose, and that is not what we're talking about here today. That is not the 510K process that exists now that was applicable to the Bard devices. It is not the 510K process that exists post the 1990 Safe Medical Device Amendments. the 510K process as exists today is not merely 20 minutes, right? I mean, you have 20 pages. You've got the statistics from the FDA telling you that the current 510K submissions, I think, are 24 times more robust than they were back then. And even at the time of this particular 510K submissions, I think they were like 5 or 6 times more robust. That the average review time was extended out more substantially because they are going through a more robust process with the current 510K clearance process than the one was at issue to the pacemaker and lower. There are 3 points that we would like to emphasize for the court today. The first is that this evidence of governmental standards regulating conduct has historically always been admissible. This particular pelvic mesh little group of cases is kind of the aberration of the rule. This is evidence that's always been admissible. If you look at the statutes, it says that it's admissible. And there's only this kind of one pocket of cases why it hasn't. And the appellate division in this case is correctly recognizing why this one is admissible actually in these particular instances. And why this evidence has historically been admissible proves true even in the pelvic mesh context. Even if you look outside of what Judge Goodwin in the MDL held that was affirmed by a couple of courts of appeal, there are many, many other judges that are looking at this exact same issue and coming out the other way for good reason.
How many of those federal cases relied on Lohr and Regal and the statements in them that 510K has nothing to do with safety, not about safety and effectiveness at all, is a rubber stamp for a device, that you should be able to sell quickly?
Yeah, that is kind of the bedrock of the vast majority of those opinions, if not all of those opinions. And certainly with respect to Judge Goodwin's opinions coming out of the pelvic mesh MDL, he is relying upon Lohr. If you look at the circuit court opinions from the 4th Circuit as well as the 11th Circuit, they are relying upon the statement in Lohr as well. And as my colleague noted before, if you look at the 11th Circuit opinion, they even say, hey, this whole thing about whether or not you're looking at a non-grandfathered device that's actually gone through a safety profile, i.e. not the device in Lohr, that's not even the issue that's before us today because that was not presented to the MDL judge. That's the footnote 3 in the Ignium opinion. The second reason why we want to emphasize is that the government standard at issue here, particularly 510K clearance, is highly relevant because it regulates how a manufacturer designs and warns about its products. Therefore, it's highly relevant to the reasonable standard that is incorporated both in North Carolina and New Jersey law. Right? Clearance is a determination by the FDA, a regulatory interpretation that there is reasonable assurance of safety and effectiveness. And the third point that we want to emphasize are the significant policy reasons that justify this evidence's admission. It encourages manufacturers to continue using the pathway that Congress and the FDA has determined is best for public health. You get innovative, life-changing therapies to patients quicker and more efficiently. You would do that while still providing reasonable assurance of safety and effectiveness because the science has shown you don't need to go through the PMA process. New Jersey has a profound public interest in developing these types of new products and promoting and safeguarding the life sciences industries. Now, if you look, for example, at the U.S. Supreme Court's opinion in Buckman, they specifically talk about the 2 different mechanisms that go about, and they have a passage that I think is important and bears upon this issue, because it talks about how in those instances when you're saying that the manufacturer should have done more than what the 510K required, and you're saying you should have gone through these extra processes, what the U.S. Supreme Court noted is that these applicants would have the incentive then to submit a deluge of information that the experts at the FDA say we don't want and we don't need, because you're going to take up so much more of our time looking at stuff that we don't need that we're not going to be able to get those life-changing and life-saving therapies out on the market quicker. That's why they have this 510K clearance process, to make sure that what they're looking at and what they're spending their time doing is appropriate for the particular case. And that And that is what is important, that we need to ensure that when manufacturers use that 510K process, that we don't disincentivize them from using that process by excluding it from evidence and allowing the juries to hear a half-baked story, to judge conduct divorced from the regulations and the checklist that guided that conduct. This evidence is highly admissible in this case and in all of cases that judge the reasonableness of conduct. So we would encourage the court to affirm the appellate division's ruling.
Thank you, Mr. Rogers.
Your Honors, given that I'm the fifth advocate you've heard from today, I'm going to try and limit to just a couple of points. I would like to touch on at least one point on each of the admissibility issue and the punitive damages issue. On the admissibility issue, perhaps a point of clarification could help us here. So we're talking about regulatory compliance evidence. Regulatory compliance evidence comes in regularly in product liability cases. So why are we here talking about should we be letting in regulatory compliance evidence? And the reason is because there's been a fundamental misunderstanding of 510K that has kind of started a number of years ago and just carried forward. And the reason is this. The 510K process came into effect in 1976 with the Medical Devices Act. Before then, there was no regulation whatsoever. The Act says every device is going to be in Class 3 and requiring a pre-market approval, application approval in order to be sold unless the FDA classifies it into Class 1 or Class 2. On day one, there are 0 devices classified into Class 1 or Class 2. By definition, everything is going to be Class 3. But Congress said it's going to take the FDA a long time to classify thousands of devices. And what are we going to do now? And what we're going to do is we're going to have a grandfathering provision. And we're going to say, look, if the product was already on the market before this new law, you can keep selling it, because otherwise all medical devices are going to have to come off the market on day one, and we're going to have to wait however long it takes the FDA to get through every single device. And then Congress said, but wait a minute, if we do that, then the people who on the day before the statute are selling the device, they get a monopoly on it. So that's terrible for consumers. So what we're going to do is, if it's substantially equivalent, then you can also sell it. This is an exception to Class 3 pre-market approval. What we're talking about in this case, although it has the same number, 510K, has nothing to do with a Class 3 exception process, the grandfathering process. We called it the transitional process. Why is that? It's because when you're grandfathered, it's to the before the statute. It's before the FDA did anything. For Class 2, the key difference is that the FDA did do the safety analysis that Congress told it to do. The standard for a medical device, whether you're Class 1, Class 2, or Class 3, is a reasonable assurance of safety and efficacy. Congress decided that if you're a Class 3 drug, the way that you get reasonable assurance of safety and efficacy is you go through the PMA process. And so absolutely, when the U.S. Supreme Court in Medtronic versus Lohr said for a Class 3 product, 510K is an exception, it was. But for a Class 2 device, the way the FDA has gotten to a finding of reasonable safety and effectiveness is through what a number of people here seem to think is a cumbersome process, in which the plaintiffs complain about, but which we respectfully submit is the choice that Congress made. And if there are complaints about that, that should be made to Congress. What did Congress decide for Class 2 shows a reasonable assurance of safety and efficacy? They said, here's what's going to happen. We're going to take a device type, in this case surgical mesh. We're going to have expert doctors review that device type, and they're going to decide, does it need to be in class 3 or does it need to be in class 1 or 2? Here, surgical mesh went through that process. 3 different panels of doctors actually went through that device type and specifically found, as they must have, that a PMA was not required and not appropriate for this device type. Had it been required to have a PMA, they must have put it in class 3. In fact, in the Federal Registers in 1982 and 1988, you will see statements to the effect of, even though this is implanted in the human body, we have determined a PMA is not required. So I think the source of a lot of this confusion is that everybody says 510K. And adding to the court's confusion, we called it transitional, someone called it grandfathered. In this sense, it is most technically, are we talking about the 510K process for a class 3 device, which is an exception to PMA, or are we talking about 510K for a class 2 device, which is not at all an exception? It literally is exactly what Congress said gives you reasonable safety and efficacy, because the panels have decided the device type is reasonably safe and effective. Those devices that they looked at get classified in a class 2, and then this one is substantially equivalent. Substantially equivalent because it either has the same technical specifications, or if it has different technical specifications, the differences do not make it less safe or effective. So is it the most straightforward safety analysis that we've ever seen? Of course not. But is it the congressionally mandated process? It is. And therefore, its regulatory compliance on the evidentiary standard, of course it needs to come in. And in terms of 403, the NJDA is respectfully submitting that this court should declare that the evidence is relevant and that the types of arguments that the plaintiffs have made is not sufficient to have it be inadmissible, even on a 403 analysis.
Would you like to move on?
I was just saying, for many of the reasons that the court has already acknowledged, which is how important it is for the jury to understand why you did something and for you not to be able to only give half of the story. Recognizing my time, if there are questions on that, I'll answer those, and otherwise I want to turn to the punitive damages statute.
Please.
On the punitive damages statute, again, let's start back at square one. What is the legislature trying to do? The legislature is trying to balance, and in some regards, balance in favor of manufacturers, what kind of damages can be assessed against them. The legislature said, okay, we're going to have compensatory damages, but we're not going to have punitive damages for drug and medical device manufacturers. And why? We already know that punitive damages are an exceptional remedy. They require a state of mind, actual malice, willful and wanton conduct. And the legislature is saying, look, if you follow the rules the FDA gives you, you can't have that kind of mental intent. It's not appropriate to have punitive damages in that case. So they wrote a statute, and they tried to do that. And as was pointed out by this court, they weren't thinking, oh, actually, we're going to immunize 2% of the medical devices, and we're not going to immunize 98% of them. They didn't use...
Wouldn't it actually be immunizing 100% though? Because once you have the pre-market approval, then all the tort claims are already preempted, so there are no cases against a device that got pre-market approval.
So because of the Express Preemption Act, Express Preemption provision in the Act, the Supreme Court has held that for the most part, they're preempted. Some parallel claims are allowed to go forward. It gets incredibly complicated. If we'd like to go with 100%, obviously that's good for my position, but if it went for 98%, if it went for 82%, I believe that was in our appendix, the same thing. It doesn't make any sense for the legislature to say, we want to find that manufacturers who are complying with the rules that they're given don't have the requisite intent for punitive damages, and then draw unbelievably hyper-technical distinctions by the method by which the FDA actually goes about looking at those things. And the most important aspect of this, I think, is to answer some questions that Mr. Cott was given, which was, we're going to look, actually, we should start, as we always do, with the language of the statute. And we look at license, pre-market approval or licensure. And there were some questions about, well, look, if it says was subject to pre-market approval or licensure under the FDCA, doesn't that mean it's its technical term under that act? And we respectfully submit, no, it isn't, for two reasons. First, as a matter of statutory construction, when we look to the last sentence, and it tells you if it's a drug, a device, a food, or a food additive, go get the definition from the FDCA. It doesn't say do that with approval or licensure. And this makes sense, because when you're thinking about what the legislature is trying to do, which is to declare that manufacturers who follow the rules that they're given don't have the requisite intent for punitive damages, then we use the ordinary meanings.
You're telling us you agree completely with the fine argument that Mr. Cott made. So, I'm going to encourage you to move on.
No, but the reason...
We're beyond 10 minutes now, and I need you to wrap up.
Okay, so the reason, though, just to say, is that the plain meaning goes in the square brackets when you read that first sentence. So the answer is you read pre-market approval or licensure, plain meaning both before and after.
Understood.
And that's it. Thank you, Your Honor.
Thank you. Mr. Criggs.
Good afternoon. May it please the court. On behalf of NJCJI, I respectfully urge this court to reverse the appellate division's holding on the Section 510K argument. The NJCJI adopts the defendant's arguments with respect to 510K and also its textual arguments with respect to Section 5, so I'll focus on policy and legislative intent issues. As this court has unequivocally explained, and as the legislative history unequivocally supports, the PLA was enacted to rebalance the law in favor of manufacturers. It's a remedial statute that's to be given a broad interpretation to fulfill its purpose. And as Justice Weiner-Abner was pointing out, or was questioning, the appellate division's interpretation would be to render it essentially a nullity. 98% go through 510K, the rest through PMA, but there's usually preemption. So it would have almost no practical effect. To counter this, plaintiffs say, well, the legislature couldn't have intended to give blanket immunity from punitive damages to medical device manufacturers. That wouldn't be a rebalancing. That would be tilting the scales all the way in favor of the manufacturers. But that overlooks that the Products Liability Act left uncapped non-economic damages, such as emotional distress, pain and suffering, that many other jurisdictions have acted to cap. Indeed, here, the jury awarded $23 million in compensatory damages to the plaintiff, almost all of which was non-economic, as well as $10 million in loss of consortium damages to the plaintiff husband, for a total of $33 million non-economic, non-punitive damages. While excessive on the facts of this case, the award shows that even without punitive damage in the equation, there's still a balance. So essentially writing Section 5 out of the PLA for medical devices, as the appellate division has done, would upset the balance between compensatory and punitive damages that the legislature has chosen in this case. Further, the appellate division's holding would create the anomalous result where only the most dangerous Class 3 medical devices are entitled to punitive damages protection. And that couldn't have been something the legislature intended, because as a general matter within the punitive damages statutory scheme, the likelihood of causing substantial harm is considered. The higher the likelihood of substantial harm weighs a factor in imposing punitive damages. So Class 3 devices are generally devices that support life, like a pacemaker. So when they fail, catastrophic consequences, death, serious harm often result. Much less so with Class 2 devices. The typical examples of Class 2 devices, electronic wheelchairs, pregnancy tests, things of that nature. They're much safer as a class of devices. So it wouldn't make sense for the legislature to decline to extend punitive damages protections to less safer devices just because Congress and the FDA made a policy decision to provide a different path for these devices that reflects their safer nature. Also, the appellate division's ruling would create tension between New Jersey law and the congressional goals of 510K. The process is designed to provide a more time-efficient, cost-efficient path to market for devices so that consumers have prompt and more cost-efficient access to them. It's the only path to market for Class 2 devices that have existing predicate devices on the market. It's not a shortcut. The appellate division's holding effectively puts the PLA at odds with Congress, and by denigrating the 510K process and treating it as a shortcut that does not adequately protect safety. 510K is about safety through equivalence. In enacting the PLA, the legislature did not intend to denigrate Congress's judgment. They intended to defer to Congress and the FDA by removing punitive damages protections for those who play by the FDA's rules. And it's not just a certain set of rules. As the past bill memorandum states, Section 5 describes, quote, protections given to pharmaceutical companies who properly comply with FDA rules and regulations, who play by the FDA's rules. So for these reasons, in some, litigation costs, including the availability of punitive damages, are ultimately reflected in the price of medical devices, and punitive damages can disincentivize production, cause supply issues. The PLA sought to sharply narrow punitive damages to keep litigation costs down, device prices down, and supply up. So NJCJI respectfully urges this court to interpret Section 5 in accordance with that legislative intent and hold that it applies with respect to devices that adhere to 510K.
Thank you.
If there are no other questions, thank you.
Mr. Slater, rebuttal.
Thank you. I'm going to start with the Product Liability Act issue, which I think I can take care of very quickly. The arguments I've just heard don't recognize the fact that we've cited multiple regulations that actually define these terms and make clear that the Product Liability Act decision was based on the rigor of the safety review. I'm going to start from the bottom, from 21 U.S.C.A. Section 360FFF. The term grassy, generally recognized as safe and effective, means generally recognized among experts qualified by scientific training and experience to evaluate the safety and effectiveness of drugs as safe and effective for use under the conditions prescribed, recommended, or suggested in the labeling of a drug as described in Section 321P of this title. As we laid out in our brief, this is for over-the-counter drugs, over-the-counter products that you'd buy in a pharmacy like sunscreen. It's a broad section of products, and it's specifically defined. That is not 510K. Licensure is specifically defined as relating to biological products. And if you look at 21 U.S.C.A. Section 379G, as cited in our brief, you'll see that there is a whole host of safety steps that must be taken.
Why would our legislature have used that? That definition wasn't in existence in 1977. I mean, in 1997, when the no, I got it right the first time when the PLA came into effect, right?
I'm looking at the legislative history going back, and I'm not going to pretend to know exactly the specifics of what was added at what point, but the legislative history for this statute goes back, it looks like, to 1938.
But you're talking biologics. Our PLA was 1987. The biologic, you're saying we should use licensure with biologic. The legislature couldn't have, right?
I believe that licensure was a term of art at the time, and it's certainly not a concept that's colloquial of anything we let you sell, because again, if it's anything we let you sell, then they would say any product regulated by the FDA. Why would they list 3 specific categories as terms of art? And finally, I'm not going to get into the pre-market approval. I think we've argued that quite a bit. So that's what I have to say about that.
Before you move beyond that, we heard an argument just minutes ago that there's sort of a broader argument about 510 510K and also a narrow argument that this 510K process reached the conclusion that it was safe and effective. Can you respond to that? Yes. As every court that's looked at it, including the court that you're reviewing, everyone has actually concluded that's not true. In essence, what the defense and the amicus on their side are arguing for is a complete recapitulation of the definition that's been accepted in the courts. So there's really no traction to that. They're literally asking to take a fresh new look and say, well, is 510K, according to this court, different than what every other court thinks that it is? And the courts...
But it wouldn't be different from what the FDA says it is, right? When the FDA puts out this, I think the chief quoted it before, the 510K program evaluating the substantial equivalence and pre-market notifications, and it just talks about how the principles of safety and effectiveness underlie the substantial equivalence determination in every 510K review. It sets forth how, although the 510K process involves a comparison of a new device to a predicate rather than an independent demonstration of the new device's safety and effectiveness, in both cases, FDA's review decision reflects a determination of the level of control necessary to provide a reasonable assurance of safety and effectiveness. So it seems like a lot of the prior court decisions went back to Lohr, which again wasn't talking about a device that had already been determined, the predicate had already been determined to be safe and effective, and instead was referring to this grandfathered process. But doesn't the FDA say that it's related to safety and effectiveness?
You just have to look to the Sisson case from the Fourth Circuit Court of Appeals. The Sisson court specifically addressed that and rejected that as a rationale. They said maybe the FDA has these aspirational statements. It's not binding on the courts. It's not an accurate statement of what the regulation says. It's in essence trying to inflate the reach of 510K, and they directly addressed that argument. So I would rely on what the Fourth Circuit Court of Appeals said in evaluating that issue. And I'd like to come now, Justice Wehner, after to exactly what you've asked a few questions about today. Regal and Lohr are not irrelevant cases, and that's what the defense is saying here. That is their position, and that is the suggestion. We have 3 federal circuit courts of appeals who have recently, as asked of counsel today, confirmed that those cases matter distinctly, and I'll tell you why. The analysis here is not about the predicate product. It's about how did the new product get to market. It's the comparative step that's taken without a safety evaluation of the product that we actually tried the case on. And to take it a step further to the reason why the prejudice and the confusion outweighs the probative value, if this comes in, if that's true that they want to say, well, there was a predicate product somewhere down the line that had a safety review, so we're going to now try all of these predicate products, and we're going to have to show the jury, well, this was for a bone patch, and this was for a hernia, and this turned out to be a terribly unsafe product, and we're going to have to spend days because that's the only way to fully pull this apart to show why the jury shouldn't care about this list of predicate products. And again, the federal courts of appeals, they know when Regal was decided, they know when Lohr was decided, they know what they relied on, and they all look back at the fact that at its base, what is 510K about? It's substantial equivalence. It's not in this case to look and say, well, was there a predicate that you can say that predicate was safe? Imagine what we would have to do at trial to prove that. It's how they got to market.
Can I ask you to address just a couple of things? Mr. Cott mentioned that 23 times during the trial there was a discussion or a mention of the lack of clinical trials. And he responds to that by saying the FDA concluded that no clinical trials were required. Is that what the FDA concluded or not?
Well, that's where I was going before, and I think that maybe I wasn't being clear. So that's the point I was trying to make before. And I'm going to now look directly to the documents, starting with what was submitted to the FDA by BARD. And it's in the appendix at 2648A.
Did the FDA conclude that no clinical trials were required?
To prove substantial equivalence.
Okay.
That was the question, and I'm trying to give context to this because I want to make sure it's not my say-so here. This is what BARD told the FDA when they were asked, and it's on 2648A of our appendix, is clinical testing needed? Not applicable. Bench testing is adequate to establish substantial equivalence. That's what BARD told the FDA. So they made it clear that clinical studies that would come in under this context are only to substantial equivalence. And as I read to the court before, Bard's expert in her report said even if clinical studies had been done comparing the Avolta to predicate devices, they would not have answered the questions raised regarding transvaginal placement of surgical mesh for prolapse repair, because again, clinical studies in the context of substantial equivalence are only to compare to a predicate product. They're not to do a medical risk benefit. So it's a completely different issue. And it would be completely misleading to the jury to say, well, the FDA, and that's ultimately what they want to do. There was nothing they couldn't do in defense of this trial. They even pointed to one piece of evidence they couldn't submit.
I want to get to the trial.
The point I'm making is the only thing they want different is to say, and the FDA has said it's okay, and to say we didn't have to do clinical studies.
I get that. You answered that question.
Okay, I'm sorry. I didn't realize.
And the second thing that he says was they could not go through a pre-market approval process for this product. Is that true?
For a Class 2 device, their initial submission is for 510K. And it's interesting, the 510K in their review documents actually reference the fact that they're supposed to take the least burdensome approach to the review. So the answer is yes, they had to start with a 510K. If the FDA looked at this and said this doesn't qualify for 510K as submitted, for example, I believe that if the entire procedure had been submitted, the FDA would have said, whoa, this isn't something we've looked at.
We get back to my original question was, is the product at issue the pelvic mesh, or is the product at issue the entire process with the arms and all the other stuff?
At trial, the issue was the entire procedure.
Okay, is that a medical malpractice case or is that a product liability case?
Well, it's interesting. It's a product liability case because that's how it's handled.
As to what product?
It's as to the Avolta and Align transobturator systems. I will tell you, this is an intellectual discussion.
That is more than pelvic mesh.
Without the procedure, the kit doesn't exist, the mesh isn't needed, the instruments aren't needed. They're only the delivery vehicles for the procedure. That's what was being sold, was the procedure. The system in the kit and the procedure. I realize it's a little bit anomalous. Can you say, well, it's a procedure? And I can tell you I filed the first case in New Jersey in 2008, and it's a discussion we've had over the years. Are these just negligence cases that they put out a dangerous procedure? But the courts have consistently treated these as product liability cases, and I didn't want to be the trailblazer to say handle it differently. But you're right, it's not a neat fit, because it's not just the actual mesh. It's much more than that. And again, I could give you citation after citation. They're in our briefs where, for example, Dr. Rosenblatt, their expert, wrote an article published in the peer-reviewed literature, Peter Rosenblatt, and said in that article, and it's in the cross-examination in the transcript, these are very controversial procedures. There's a lot of doubt about the procedures and the techniques, and maybe when we do long-term studies, people will actually start to have confidence in these procedures. That's how they're discussed in literature. You heard about experimental? Where did experimental come from? Dr. Weber, who was our expert.
I didn't ask about any of that.
Okay, I won't go there.
But I want to go there. Comment, if you would, on the basic fairness argument that we've heard throughout this case, that the references to experimental, the references to lack of clinical trials were unfair without the ability to present any reference to the 510K process. And if you would, tailor that not only generally, but to the question of punitive damages. Go ahead.
Because when we talked about experimental, it was in the context of an ACOG, American College of Obstetrician and Gynecologists, procedure written in February of 2007 by our expert, Dr. Weber, that said these procedures are new, they're untested, and until there are actually clinical studies with proper informed consent, they should be deemed experimental until studies show safety and efficacy and that it's better than the procedures that are being displaced, which were suture-based procedures without mesh. Parenthetically, what happened was the industry went to ACOG and they wanted to get the word experimental removed, not because they were worried about 510K, but because experimental procedures aren't paid for by the insurance companies. We have the internal documents from the companies that that's what they talked about. They, in fact, had a document that we saw at trial that they wanted to put my expert in cement shoes in Rhode Island. It's a real document. It's really what they said, not because of 510K, but because experimental would have gotten the procedures not to be paid for. But this was a medical society practice bulletin saying that. 510K says nothing about that. 510K clinical studies, as admitted by their expert in their own expert report, don't speak to medical risk benefit. They only talk to comparing this mesh device to a prior mesh going back to surgical mesh. They're completely irrelevant.
Fairness? That's the question. You got to say experimental. They didn't get to say 510K. We get your argument that 510K doesn't go to this. They didn't get to say it.
But the reason...
And in terms of experimental being off point in terms of what we're talking about in terms of the device and warnings?
No, that's not what I'm saying. Experimental is off point to 510K because it was not put in. Our expert didn't say these are experimental because nobody ever cleared them and nobody ever looked at them and somebody did it.
Ever explained to a jury? I mean,
it was explained in great detail and she was cross-examined. And I will say they had the ability. I'll tell you, Judge Cruz, they had the ability to put in every single stitch of evidence they wanted to put in at trial. There was absolute fairness. The only thing they couldn't do is plant the FDA flag in that evidence. And that's because the FDA evidence, for example, of clinical studies, had nothing to do with the clinical studies that we were talking about at trial, which, please don't forget, they introduced the concept in their design control process when they picked an ISO regulation standard, not a regulation, a standard that said you can do studies or you can do a literature search. But if you do the literature search, their expert admitted you have to be robust and objective. You have to look at all the countering literature. And if literature says studies are needed, you have to take it seriously. In this case, we showed the jury that the studies they relied on said studies were needed. And saying, well, the FDA said we don't need a study would have been completely 100% irrelevant because all that study would have spoken to is substantial equivalence to something else that the jury wasn't learning about. And then we're down into the rabbit hole of let's talk about the predicates, let's talk about everything that came before. And that's why, again, the abuse of discretion standard has to be respected. And responding to what you said, Chief Justice Rabner, about punitive damages, it's the same exact question. When you say fairness, their state of mind only mattered in terms of how they designed the product and what warnings they provided. Neither of those decisions were reviewed for safety and effectiveness on a clinical medical risk benefit level by the FDA because that's not what they do. And you can look at the documents, it's not there. And their expert admits it, that such a study, per the FDA, would not have touched the issues at trial. Again, Sisson says, the basic question is how much information does 510K clearance provide a jury about the safety of the underlying product? And is the value of that information substantially outweighed? That's the question. That's the weighing question a trial judge has to make. And that's why the abuse of discretion standard has to respect it. Even if one says, well, you know, I think I could manage the trial and I could give a limiting instruction, you have to say, well, the trial judge, though, who's managing, and remember, the judges who have made these decisions are the MCL judges who ran, at one point, I think we had over 12,000 cases. The federal MDL judge managed over 100,000 cases. These are the judges who are most expert with these cases in the United States. Their judgment has to be respected. Even if you say, well, you know, I think I could differ with that and I could do it differently, that's the core of the abuse of discretion standard and policy. These are the most expert judges in the United States. And look at every appellate court, other than our appellate division, has said, we understand the rationale, we see what you did, and we were going to respect that and we're not going to touch it. And that's what we ask you to do, is to say the abuse of discretion standard matters. We've been in the weeds all day where we belong to go through this. And it's harrowing. But the bottom line is, the trial judge went through all this. Nobody, including the court, the appellate court, has said the judge didn't consider something. His decisions were very detailed. He considered everything. He was very patient. Full proffers made. So at that point, we have to say, okay, we have to respect what you did because there's nothing he didn't consider.
So let's get out of the weeds right now. Is there any other point that you wanted to make before ending your rebuttal?
Okay. Give me one moment. I just want to look and
neither one of us can count to 8 minutes. I can assure you of that.
Oh my gosh. Time stands still, and then it moves too fast. A couple of the cases that were cited by the defense, I think it's important for me to comment on.
I'd ask you to please do so briefly.
I'm going to do it very briefly. Feldman and Kendall were PMA product cases. They were not 510K. And what mattered there was the excluded evidence was substantive evidence that went to the heart of the claim. In the Kendall case, the substantive evidence was adverse event reports versus total sales that was directly answering the plaintiff's experts' causation opinions. That this is not substantive evidence. Nobody has made an argument that 510K clearance, by being kept out, deprived Bard of submitting any substantive evidence at trial. And I will say one other thing. The Agnium case, I don't know if I'm pronouncing it right, from the 11th Circuit, directly addressed the question of whether or not safety testing, which was the theme of the plaintiff, should have opened the door or allowed in the clinical studies. And they say that begs the question. It doesn't, you can't change 510K into something else because the evidence gets into the lack of testing. They literally looked at that exact issue. And the last thing I'm going to say is this. There is no way, because I have to say this as my last thing, there is no way for a court, from our perspective, on this record, with the pelvic mesh devices, with all of the things that are tied up in that, all of the facts, all of the history, to have adequately protected this jury, from our perspective, from confusion and prejudice. That's what the judge found. And we have multiple federal courts of appeals who respected the decisions of Judge Goodwin. And I believe in one of the cases, another judge in West Virginia sat by designation because while Judge Goodwin was trying a case in Florida, the other judge tried a case in West Virginia. That's the fact. There's no way to adequately protect this. But even if you disagree with the trial judge who thought about it, we ask you to say, okay, he's the trial judge, these are the MCL judges, we have to defer to their discretion. Thank you so much.
Mr. Potts.
Mr. Slater just agreed with me that we were required to use the 510K process. So on Section 5, what he's saying is that Section 5 does not protect us from punitive damages because we were required to use the 510K process, even though, as reflected in some of the briefs, about 90% of the products go through 510K. And it is hard for me to believe that the legislature would have said, we're going to give protection for devices from punitive damages, but we're not going to give it when the Congress of the United States and the FDA requires the manufacturer go through a pathway of Class 2 clearance. The other point I want to make, and I'm going to go a little slower on this because it's a little complicated. Mr. Slater's arguing words of art. That's what he's arguing. And that, as I said, is the legal issue. If this court says, yes, it's word of art, drugs will never, ever get the benefit of Section 5. And the reason I say that is drugs do not go through pre-market approval or license or generally recognized as safe. Drugs go through an entirely different process, which is called the new drug application. So if you accept the argument that plaintiff makes on words of art, you've just reached an absurd reading of Section 5 because it would result in drugs not having the benefit of Section 5. Finally, on whether the FDA required clinical testing, and Mr. Slater said that that was related to substantial equivalence, I'd call the court's attention to the Appellate Division Appendix, page 2563 through 717. That is where the FDA said no clinical testing is required. And as I read the document, it is untethered to substantial equivalence. Mr. Chief Justice Rabner, that completes my rebuttal, but I'm glad to answer any questions that the court has.
Thank you, Mr. Kai. And I want to thank everyone. It's a privilege to hear such very fine arguments. I apologize that we didn't have more time for all of the amici. Mr. Cohen, sorry about that. Court's going to take the matter under